All right. Thank you very much. Thanks to all the organizers and for everyone for having us. This is, as mentioned, a really, really important and yet very often misunderstood topic. It's misunderstood somewhat frequently, including a whole bunch this very week. I know that all of us on the panel had really hoped to be there in person as well, but for a variety of reasons, it ended up that none of us could make it. So I appreciate that we were able to do this virtually, but we certainly miss being there and getting to see everybody and interact with everyone in the audience. So for this panel, we have honestly three of the best experts that I could think of from somewhat different perspectives to talk about Section 230. And when I say different perspectives, often on panels, the way they're set up is that you get people who have disagreeing views, and the point of the panel is to set them up to sort of argue with each other. That's not what we're going to do today, because I actually don't find that to be particularly insightful or useful in any real way. But I think what we have here are three people who have different perspectives in the traditional sense of different perspectives, which is they're looking at it from different views, and therefore they can help provide those different perspectives in a way that I think will be really, really useful. The bios of all three you can look up and read, but I'm going to give you sort of a shorthand version of who our three panelists are, so you can get a sense of where that perspective is coming from. We have Cathy Gellis, who is a lawyer who helps explain the law to people so that they can understand it and not mess it up, hopefully. We have Kate Klonick, who is the law professor, who has spent probably more time than anyone else understanding how the law interacts with content moderation and how the companies engage on that. And then we have Adelin, who has spent years working in various companies in a variety of different trust and safety roles and understands the trust and safety process and the way that companies work on these issues and how 230 impacts how companies handle different questions around content moderation. So we get these sort of three important different views. For the panel, I'm going to start out with going to Cathy and asking her to sort of give the quick summary of what is Section 230, in the most basic sense. What does it say, and what does it actually mean? And then we'll bring in the other panelists. So Cathy, you want to get started?
Okay. Thanks, Mike. Yeah, actually, I want to sneak in the comment that what is the one thing I want everyone to know about Section 230, and that is that it's not what's broken. It's one of our best defenses against what's broken, and we mess with it at our peril. And to understand this, we need to understand sort of the world that we were in before we had Section 230, which was a changing world. Get in your time machine, go back to the mid 90s when a couple things are happening. One of the things that are happening is that online systems are getting really popular. They're starting to enter the mainstream, leaving academia. Some of them weren't actually the internet themselves. Some of them were walled gardens like Prodigy, America Online, CompuServe. Eventually, they started to touch the World Wide Web, which was also becoming popular. But things are starting to happen in a variety of online contexts. This also caused some people in Congress to worry about, oh my gosh, some people in Congress were like, this is really cool. What a nice thing that we can have with the internet. And some people were like, oh my gosh, this means we're going to have porn. And I realize that this is not the technical term that we're going to have, but this was a moral panic. They were not interested in the technical term. So you have some people like, shut this down, and some people are like, bring it on. And so you had this collision of tensions. And then you had this really horrible lawsuit that happened in a state court in New York called Stratton Oakmont versus Prodigy, where a Prodigy user had allegedly defamed somebody, and then that somebody decided to sue Prodigy for taking. They should be liable for the terrible things their users are saying. And the problem was that a judge looked at it and said, yep, that sounds good to me, which would open the door to obliterating every online service because online services have an awful lot of content. Even back then, they had tens of thousands of users, tens of thousands of content happening across its systems monthly. Like, how could you possibly be responsible for that? You wouldn't know what was there. How could you police it? So all of a sudden, it's like if you're in business hosting and facilitating user-generated content, your business is in big trouble, because part of the problem is there's certain defenses like the First Amendment, and we'll talk more about that over the course of this panel, that the First Amendment would provide an awful lot of protection for things that platforms do in hosting content or taking content down. But what good is the First Amendment if you have to go to court to defend that right? So you're looking at a situation where anybody who's helping like that, because the internet is a system of helpers, you need somebody to help you get your idea from point A to point B. Like this panel, we're not just talking about Section 230, we're demonstrating Section 230, because I'm sitting here very far from you and getting my ideas from my head to your ears via an awful lot of helpers. We've got my ISP, we've got Zoom, we've got other ISPs, backbones. You need these helpers, or else the internet does not work and these ideas do not get shared. So you have to make it possible that a platform, a service, a helper can't get shut down by the threat of lawsuits. We want also a second thing for platforms to do, because one of the things that was a problem for Prodigy is, and that kind of caused the court to say, yes, totally fine to have you be liable, is that Prodigy actually was trying to take care of its community. They actually said, we try to monitor content. They obviously couldn't do a perfect job. We will talk more about why it's not possible to do a perfect job at that scale, but they wanted to give it a shot. And what, we're going to say no to that? Like, nope. If you're going to be in business of helping content, you have to be totally indifferent and hands off, and like whatever crap happens, you got to let it happen, because otherwise you won't be able to help any expression. Like, this doesn't make sense. So a couple of members of Congress, then now Senator Ron Wyden, then Congressman Chris, who was then a representative, and also Chris Cox, who's a representative, are like, this is not a good situation. We want platforms to do two things. We want them to be partners with Congress's goal to get the most good stuff online, diversity of expression, ideas, services, e-commerce, all sorts of stuff, and minimize the most of the worst. And what they realize is that, okay, the way to do that is a carrot-based law rather than a thou shalt not stick-based law. So you incentivize them to do the best they can on both fronts by making it legally safe for them to do the best they can on both fronts. And that led to Section 230, which is a two-pronged immunity that basically says you are, well, we'll talk, let's get to the specifics of what it does, because the two things are, you're safe if you leave content up, and you're safe if you leave content down. And they do this by basically with what is now called the 26 words that created the internet. I'll read them to you, but I've never managed to recite them in a way that is ever understandable, so I'll translate as soon as I recite it. But no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. What that means is whoever was the user who created the user-generated content, expressed the user-generated content, whoever made the mess is responsible for the mess, but not the helper, not that platform, not that service, not the facilitator that helped the expression happen online. And that is key. Now, there's also a second immunity, which explicitly goes towards moderation practices. And it's pretty broad, because although it talks about, yes, we want you to get rid of certain types of undesirable content, it also has language otherwise objectionable, which is a broad brush that platforms can use lots of judgment for. Also, the First Amendment allows platforms to exercise lots of judgment. But again, what's the point of the First Amendment if those rights are going to lead you dry in legal costs, having to go to court to assert that discretion? So they put something explicitly into Section 230. It turns out that over the last 20 some odd years, it's been that first bit, the first 26 words, that have actually done a lot of the heavy lifting, even for moderation decisions. But basically the idea is that you have these First Amendment rights, and we want to encourage you to use them, to leave up the most good content, take down the most bad content. And this is what they crafted. This is the statute. It got tucked into the Communications Decency Act because Congress was really worried overall, like all of Congress, not just these congressmen, the people who were afraid of the porn really cared about internet hygiene. So they passed the Communications Decency Act. Most of it was struck down by a case called ACLU versus Reno, which made the very important point back then that the First Amendment does indeed apply online. But the piece that was left standing is Section 230. And as people have said, it is the 26 words that have created the internet and allowed everything to happen that is good, bad, or otherwise. And so the rest of it is we'll talk about what can we do about the otherwise without actually ruining this, because if you start poking holes in it, it's kind of a balloon. It's not going to hold together. One poke and you kind of lose all of its strength and value. So let's not do that. And we'll talk more.
All right. So, Kate, I'm going to go to you next. I think you, more than probably anyone else, has really gone into the history of, how the different companies have moderated and how they sort of, as the internet grew, they sort of learned, both why Section 230 was important to them and sort of how they could moderate. So do you want to talk a little bit kind of the I guess the evolution of content moderation, on the internet thanks to Section 230 for the most part?
Yeah, of course. So Cathy, great lead in as always. I will kind of start with the idea that, as Cathy mentioned, there is this carrot kind of for private companies to begin moderating where the government can't, to take down kind of the parts of the internet that we don't want in certain places, but without the kind of censorial regime of the government. And so what you kind of have starting in 2004, and what I looked into in the last, what I've basically studied for the last 6 years, is how like major companies that host user-generated content, primarily ones that engage in what we would call commercial content moderation, which is that they pay other people to review flagged content that might be against their terms of service. Basically, how they put that regime together, how they started establishing rules, how they began to judge content against those rules, how they did that for a global audience, how they did that at scale when Facebook, for example, went from 2004 to like basically totally global in 2008, out of kind of the college age student American-based approach, and went into kind of opening up to all ages and all over the world. How that basically ended up changing the process of the rules and how they got updated and how they got applied. I want to kind of contrast that briefly with what I would call other types of non-commercial user-generated content moderation. That's like your Reddit, your Wikipedia. That's volunteers essentially who are users on the site, and the site rewards them and empowers them to basically be moderators for subreddits or various small communities. It is how a lot of content moderation is done. It is a slightly different thing, and it is not specifically what I studied because it is a little bit more decentralized and was harder to study. So what I kind of focused on was, what are these big actors? Twitter, YouTube, Facebook. Like, what were they basically doing? And what I uncovered, at least, and the most information that I was able to glean, although this was like largely true for all of the platforms, but for specific dates, I'll just stick with Facebook, was that around like 2008, there was a group of college-aged, recent college grads in Menlo Park, basically doing adjudication on content with this, this normative base of like, if it makes you feel bad, take it down, take down Hitler, take down Nazis, take down swastikas, take down revenge porn. If like they can, you can show it, all of these types of these things. That quickly became an untenable standard. Just like if you had a small town and you could tell 10 people don't drive too fast, and that was a perfectly administrable rule when there's only 10 people and everyone kind of knows what that means. But when you have like 10,000 people, you need to set a speed limit, you need to have rules, and you need to be able to make exceptions to the rules and to figure out when you're going to allow someone to go slightly over the speed limit if they're trying to get to the hospital, or but not when they're driving drunk. So those types of exceptions end up being kind of called out. And what I found was that Facebook had developed essentially kind of what is almost like a common law type system, which was that they had these rules and then they were constantly reevaluating them as facts and kind of other things came into play and making exceptions. And so there are some ones that are very famous now. One of them is like, they had a bar against topless nudity for women on the site. Then they had to make, people were very upset with this because they wanted to post intimate photos of breastfeeding their child or things like that. But then they had to try to figure out how to define a child. And then they had to figure out how they were going to define actively breastfeeding, which is like, or like the 5 minutes after breastfeeding while the child falls asleep. All of these types of things that had to be basically critically define the norms that are very amorphous and subjective, basically translating them into these objective means of looking at content, and then doing that across very different normative intuitions between the people who are posting these photos and having them reported and the people who are adjudicating them in the Philippines or India or Warsaw or wherever they were. Something that you couldn't rely on at all anymore was this very normative, very subjective idea of, if it makes me feel bad, take it down. If it's sexually explicit, take it down. That turned out to be a very different judgment in Hyderabad than it was in New York City or even Nashville, Tennessee, or anywhere else that you were kind of adjudicating this type of content. So Facebook had one set of rules and was trying to enforce them globally under the auspices that there was, like, with the kind of the language that this was one global community, even though we all kind of know that there's no way that there is one global community that we can all agree on what the norms are for different types of content. So that was primarily what I've studied and what I continue to study. And the norms around this are just constantly changing. Like, and so are the rules that these sites enforce and how they enforce them. One of the big changes you've seen in the last couple of years is around disinformation or misinformation. You've seen changes in how they treat public figures and political figures, how they define those people for purposes of, like, if you have an involuntary figure that suddenly gets bullied versus you have kind of a public figure that is a political figure like Donald Trump. All of these various types of different kind of changes to these rules and how they're constantly going. And those do happen within the realm of 230. I typically talk about 230 now in my work in the sense that for these giant players, Facebook, Twitter, and YouTube in particular, that Section 230 doesn't have the there that it used to have. The idea was to create this kind of incubation and this kind of process and encouraging kind of good content moderation. It is really not clear how much changing Section 230 would really hurt Facebook's bottom line anymore, or make a huge difference, just because these suits and the impact of them would probably be small, and defamation and other types of communications torts are still very hard to prove across kind of across 230, even without 230. Nevertheless, I think that, like, the politicization of it has muddied kind of the very essential nature of what the law is, and kind of overcomplicated something that I think is fairly straightforward. So that's where I will leave it.
Great, thanks. And I think I want to get back to some of what you said, but let's move on to Adelin for next, just because you were actually working in these companies, many of these companies, as a lot of this was being put into practice, and sort of, you know, saw from the inside how companies dealt with these questions, and you know, in some cases, you know, created trust and safety efforts and organizations. So can you talk a little bit about, you know, sort of that view from the inside? You know, that Kate sort of mentioned some of the thinking, but would love to hear your take on what it really was like on the inside, and how you were thinking through these things, and, you know, the potential risks and liabilities as it relates to 230.
Yeah. So it was funny, I was actually, when I was asked to be on this panel, I was kind of like, well, I'm actually not an expert on 230 or the law, right? Like, I don't have a background in the law. And when I started doing this work, you know, as a person working on advertising policy, the idea of Section 230 was never kind of at the forefront of my daily operational work, right? So I think there is sort of this level, there are kind of two levels of abstraction, really, you have 230, the law, which is creating a context for the tech companies. And then you have these teams within the tech companies that are trying to create rules about what's acceptable or not acceptable in order to sort of align themselves with Section 230 and not get into trouble with Section 230 or kind of lose their immunity. And then there's another level of abstraction when you go from the content policies themselves, which are the rules of what can or can't stay online, to the operations folks. And so I would say, like, as a frontline reviewer, you're not thinking about Section 230 on a day-to-day basis. So that was kind of my entry into trust and safety, doing kind of reviews on pages to see if they were, scammy or if they were kind of problematic for users. And then I started moving a lot more into the content creation space. And even at the beginning, I would say, like, and I'm just kind of like drawing on my own experience. Personally for me, like, I didn't feel like I got a ton of context around Section 230 when I first started out, right? So a lot of the work that I was doing was around, hey, like, who do we want to be as a company? Like, what are our principles? What are our standards? Like, what's, what are we doing to prevent abuse of our users? And what can we do to just make this environment a lot safer so that, and for, very, idealistic reasons that existed at the time at the places that I worked at, but also very pragmatic reasons, like users need a place, right, that for them to feel safe, and then we can actually grow the platform. I have to say, like, the places that I've worked at really prioritized concepts like freedom of expression. And so that kind of, idealistic space contributes to a lot of policies that meant that we were usually inclined to leave more content up and fight against requests to take stuff down. But there are plenty of other companies where there are teams that don't value that as a principle, and we can talk about various companies where they sit on different ends of the spectrum. And for them, they're going to create policies that are more likely to say, like, hey, like, we don't want to fight this particular issue, and we don't like any sexual content at all on our platform because that's not what we're about, and we're just going to take that down. And so I think, the fact that there are so many different, organizations and companies that have different principles around and missions around, like, who they want to be, kind of also muddies the Section 230 conversation, I think, when you start looking at the law. But just in terms of, like, my own personal experience, like, that's the idea that these company operators would be thinking about 230 every day, like, that's not a reality, right? Like, our lawyers think about it, our legal teams think about it, but at the trust and safety policy level and operations level, that's not something we wake up, thinking about and go to sleep kind of worrying about, right? So I don't know if that's helpful, but I'm happy to kind of do more follow-up questions on that.
Yeah, I actually think that's really helpful. And actually, in some ways, I think that is a really important point. And it's actually a feature of Section 230 that the frontline trust and safety people don't need to be thinking about it, right? Because you have other laws that are in some way structurally similar to Section 230, like the DMCA for copyright issues. And in that case, specific decisions that you make can impact the liability of the company. So when it comes to copyright, the frontline trust and safety team actually has to be very aware of the different elements of the DMCA and the law to keep your safe harbors. The nice thing about Section 230 is that it's not like that, where you have a sort of safe harbor setup where you have to, like, do this, this, and this to keep those protections. But Section 230 is very broad, and it allows you and the teams that are doing the trust and safety decisions to make those decisions, to say things like, we want a safe platform, without thinking about, does that open us up to some kind of liability if we miss something, if we make a mistake, or, which was the situation in the Stratton Oakmont case that Cathy discussed. So, one of the things that's been sort of, sort of top of my mind for a long time now is that, Section 230, as Cathy described, is this sort of very straightforward thing. The key part is 26 words, and yet it is sort of so often misunderstood. So I wanted to get a little bit at the root of why and how it's misunderstood. So Cathy, I'm going to go to you and say, like, can you explain like why, to the extent that you can, why is it so complex and confusing to people when they're thinking about 230?
Well, okay. So one of the things is that when people think of law, they tend to think of law, I think, in punitive terms, thou shalt not. And that's why I talk about it as being a carrot-based law, not a stick-based law. We're not used to carrot-based laws. It turns out, I think that's a really effective tool for policymakers to use, and maybe we want to use them in other contexts where you actually get more of what you want when you create the incentives for people to do what you want, more than if you just scare them. Like, to use an example in the Section 230 context, like, you want the platforms to be able to use their resources effectively as they can, but if they have to worry about specific forms of liability, like for instance copyright, it warps their ability to make good decisions overall, because they're going to have to allocate some resources to dealing with the copyright question, whether it actually made sense to, and maybe it causes them to be a less good, less well moderated platform after all, because the punitive nature is kind of usurping a lot of their resources, telling them how to spend it, even if it isn't quite the right way to spend it overall. So to answer that question, like, one of the reasons people don't get it is because this is not intuitive to us, where we throw this sort of thing into the universe to get good policy outcomes. We're not used to it. I think we should get more used to it. The second thing is it has absolutely no business being here, but it's become a political punching bag. Like, nobody should be thinking about Section 230. I don't even want to think about Section 230. Like, we are wasting our time on this. And what it really is a proxy that, like, it worked. The internet is doing what it was designed to do. It is connecting all these people. 7 billion of us can actually be connected in all sorts of really interesting, dynamic ways. And it turns out that as a civilization, this is unprecedented, and we're not very good at it. And some people kind of suck, and they use their ability to connect with other people in really terrible ways. We've got some growing pains, legitimately. Like, I don't want to gloss over actual harms, but I do want to point out that, like, if 99.9999999% of the internet is awesome, that also means that because there's so much of it, the one little sliver of percentage over in the corner is going to seem like an awful lot of stuff. But you don't want to kill that other 99.999% of good stuff. And we kind of are, because bad stuff is happening. We're alarmed by the bad stuff that's happening. We want to deal with the bad stuff that's happening, and we should. But the math is coming out where bad stuff is happening on the internet. Section 230 has enabled the internet. Therefore, Section 230 must be bad. And that's not the math. That's not the math. Other things could happen to buttress it, but right now it's the only poor little law doing all the heavy lifting to give us any internet at all. We really should be looking more closely at what are the harms, what are the things going wrong, and what can we do to tailor regulatory solutions around those things without taking out the bit that's actually working for us. So we shouldn't be thinking about Section 230. Let's just move on to the next panels.
I don't know, Kate or Adelin, have you had any other thoughts related to sort of how come that Section 230 has become so prevalent?
Yeah, I think that there's also just I think it is political because basically there has been both, I think, a little bit overemphasis on what Section 230 did to create the internet. I mean, it is like, you know, we have Jeff Kosup's book, The 26 Words That Created the Internet, as Cathy kind of referenced. This is like EFF and a lot of other kind of actors have long lauded it and protected it. There have been, you know, it became kind of a bastion of a lot of people saying that, like, but for Section 230, the internet wouldn't have, like, we wouldn't have the internet like it is today. And so, like, as Cathy said, that is both bad and good on different days, and depending on kind of what site you're on and what you're looking at. And so I think that basically when around 2016, 2018, which I would labor to point out was just 4 years ago, there started to become this massive backlash against big tech and against Facebook. And we had Mark Zuckerberg testify in Congress for the very first time, and, you know, Congress people asking him to fix their email, and like it was just a giant like disaster. But like there has been only in the last 4 years basically has the fact that I would say that only in the last 4 years have people basically become aware that websites are capable of this type of censorship or this type of content, and that they do it regularly. Like, people were reporting this since, like, Jeff Rosen had pieces out in 2012. They were not published in like Nothing publications. They were not like on his blog spot. It was in like the New York Times Magazine and Wired, talking about how this was like the Google, the deciders on YouTube. There were lots of people writing about it, but there really wasn't this huge shift until 2018. And I think that basically then people were like, well, this is a lot of power for private companies to have. That's terrifying to us. I guess we should empower the government to try to save us from private censors, without thinking really that we have had problems with government censors for longer and to more ill effect in a lot of countries in a lot of ways, hence the First Amendment. And so then it kind of became, well, like, what's blocking us from any type of reform? And I think that the idea that there was one bill that a lot of techno-libertarians had lauded as basically being this but-for cause to the internet today just made it a perfect punching bag for both sides. It has what I call kind of the horseshoe effect. It appears that there is bipartisan support for 230 reform, 230 repeal. There is no such bipartisan support for the conservatives and the right think that, like, basically all of these sites are over censoring. They would want to get rid of Section 230 for reasons that don't totally make sense, and hew to basically a First Amendment type, keep everything up on the internet, don't take anything down, which I endeavor to point out, as Cathy says, like, would mean that we would have Joe Rogan and and misinformation and lots of pornography, which might upset a lot of conservative people as well. And then on the same side, you have people arguing for 230 reform on the left, and some of them are arguing it for privacy reasons that don't entirely, privacy reform, which doesn't entirely make sense. And some are arguing for it for free speech reform, and they want more stuff taken down from the internet. They want actually the platforms to be incentivized to remove more bad content, to remove more hate speech, to remove more disinformation about health and other types of issues around COVID. And so what you actually end up having is that you have three different things that are all calling, in the broadest of possible, like dum-dum terms, and to use a technical legal analysis, reform Section 230, like repeal Section 230, but none of like the actual mechanics of any of their bills are going to even touch, like, or be even like anywhere near aligned on like where this is, what they would do with that reform. And so it is, and also I would just really quickly, sorry to talk so much, I would just endeavor to also point out that there is no incentive for them to actually solve the tech problem. It is a punching bag for everybody on both sides of the aisle, right? So no one actually wants to get rid of it. They can score political capital, whether it's votes or donations, by going after big tech, saying that they drafted some bill on Section 230, knowing that it doesn't actually have bipartisan support as like they claim or people are claiming. And so like, I know this is a kind of a cynical take, but this is like, now after watching this for 4 years, this is 100%. Like I've looked at so many Section 230 reform acts over the years, and like this is 100% kind of what I think it has been going on, and why I also just don't think that I'm sure we'll talk about later, that it would do any of the things that people are the most upset about. Like it just doesn't actually get at what people are upset about with the internet.
I think Kate's spot on in that like last bit that she talked about, just because, you know, as I sit here and kind of look at the different sort of case studies that have come up, which Mike, I know you've been tracking for many, many years now, on like different instances of people saying like, hey, I got censored, you know, by such and such platform, or hey, like this platform isn't censoring enough. So I put myself in the shoes of those reviewers at times when I look at these particular case studies, particularly in like the era of, you know, wanting to reform or repeal 230. And I just sit here and I wonder, as an ops person, like, well, what would I do, right? Because you're, as an operations person within the company, you're being ping-ponged and being told, oh, you're taking down too much. Oh, wait, you're not taking down enough. And that is a very difficult and challenging position for, you know, yes, tech companies are, these corporations, but there are real people who are trying to do their jobs on a daily basis, who are motivated by trying to keep, online communities safe. And they're having a really difficult time. And they are actually, being punching bags for when things go wrong, because they're at the front line of making all of these decisions. But I don't think that it's purely kind of like the review team's fault. It's really like the context in which they're operating is just really fraught right now and really challenging. And so it's always been a lose-lose situation, but it feels like even more recently, it's been even harder and more challenging for the individuals who are at the front lines of making these decisions. And then the other thing too is that the Section 230 conversation is very much a US based one. And the teams that are doing this work are doing the work on a global level. So on top of having to think about 230, the teams are also impacted by the regulatory environments in different regions, and Kate and Cathy can definitely speak more eloquently on these laws, but there have definitely been more complicated issues arising in Australia, right, and like in Singapore, in Europe, all around what teams are supposed to do, or what these companies are supposed to do with content. And so basically what I'm saying is that it's a very challenging time for your frontline trust and safety reviewer, because there are so many considerations that they're trying to balance.
Yeah, I think that's a really good point. And one of the things that I recall as kind of that started the kind of shift in the debate to like actually everybody focusing on 230 was there was I don't remember the year, but it was probably 2018 where Wired had a big cover story about Facebook and content moderation, and multiple times in the article they said that like Facebook told the Stafford, the content moderation team, basically default to not taking stuff down because they were afraid of losing their immunity under 230, which is wrong, right? You don't lose, you can't under 230 unless you're creating the content as the company. You can't lose that immunity. And I had written something and sort of yelled at the reporters who wrote that article, and sort of the feedback I got back was like, yes, you're right that the law doesn't say that and they couldn't, but that is what they told people internally. And I was trying to understand that, and I spoke to some people, and the sense was, as like Kate mentioned at the beginning, you have these global teams and you're trying to, put together a rule that that you can send off to the Philippines or India or wherever around the globe, that can be easily put into practice by the teams that Adelin worked with, and the easiest thing to say is like try not to leave up as much as possible to avoid like having the knowledge to that puts us at legal risk around the globe. The different standards are changing now, but there is this kind of global question versus U.S. question that I think becomes really, really tricky when it comes into putting these things into effect. I did want to talk, just because I think a point that Kate that you raised, sort of the very different approaches of sort of the Republicans and Democrats in terms of the bills that they've put forth, where it does feel like one side is basically saying like leave everything up, and the other side is saying take everything down, or take a lot of stuff down, which is sort of a shorthand version of what a lot of the debate is. I do think it would be useful, and Cathy, I'm going to go to you for this one again, to talk about operationally what would actually happen if 230 were taken away. What would that actually mean for the various companies? And I know Kate, earlier said like for Facebook, it actually probably wouldn't have that much of an impact. But I think it's also important to talk about other companies where I think it would have a lot of impact.
Yeah, I agree with a lot that Kate is saying, but I actually think that Facebook is playing with fire, because like there's a certain point where yeah, they've got cash in hand, but cash isn't your only problem. Because the real issue with Section 230 is it's that lawsuit prevention. It's you the First Amendment is doing most of the operation of what 230 ends up doing. Like you have First Amendment editorial rights about who you want to associate with, what expression you want to associate with, and you get to exercise those rights. But if somebody's going to sue you for how you exercise those rights, and you're going to have to defend each and every decision, then all the stuff that Adelin is talking about it's plenty fraught with just figuring out what those decisions are going to be. That's an extra overtone. Like, how are you possibly operationally going to be able to continue to make moderation decisions with any nuance and, you know, trying to get it as right as you can for your user base, if that's the pressure of like every decision is just going to be like, we're going to be calling our lawyers, and calling lawyers is expensive. You calling them, it's 4 digits. Them doing something for you is 5. You actually going into a litigation, it's 6 and above. So you cannot possibly do this at scale. And even for Facebook that has the cash, there's still only a finite amount of cash, but you also have like a management issue of like, how do you actually manage all the lawyers that you've now had to dispatch? Like, are there even enough lawyers in the world who could defend Facebook for all the decisions that it needs to now defend? So I think even Facebook is glib, but this is certainly devastating for any smaller company. And we've seen this happen because like with the DMCA, which is much, much weaker, where it actually was protected for, it wasn't a decision to take down. It was, in this case, it was decisions to leave up, to allow certain forms of user-generated content that somebody's like, I think my copyright was totally implicated and I'm going to sue you, you stupid platform, for ever letting people post stuff that was offending my copyright. The platform won. It had the safe harbor under the DMCA, but it was bankrupted by the time it got to the point where it was vindicated. So what good did that do?
Just for people who aren't aware, you're talking about a company called Veo, which I think a lot of people don't necessarily remember, but in the early days, Veo was a pretty strong competitor to YouTube, and actually, of all things, was I think founded by Michael Eisner, who had been chairman of Disney, and he founded this competitor to YouTube called Veo, and they got sued out of existence, even though they won the case.
Right, it was too late. They won it basically in a bankrupt form, which was kind of good for everybody else to the extent of like, at least we got to that decision, and that's a helpful decision to have on the books. But now everyone's complaining, oh, you know, Google should have competitors. Well, it might have been nice if you didn't accidentally kill the competitor it would have had. Because actually, to avoid the question a little bit, like one thing that I think is coming up is, you know, I was thinking about it with well, why is 230 breaking? Okay, so let me close the loop on that. The problem with 230, the reason we need to keep it is because ultimately 230 is lawsuit protection. The content and the substantive decisions, this really backfills for the First Amendment and what the First Amendment has to say about expression, free expression, the diversity of expression, editorial choices, things like that. That's a whole separate conversation, but we're talking about what the First Amendment does. But it's no good for the First Amendment to facilitate editorial choices and also to allow diversity of content to be up if you're going to get obliterated by lawsuits. So now we're talking about it. And the problem with all the Section 230 reform is they all create the threat of litigation. They may move it. It may not have to do with ultimate liability, but if you have to litigate whether you're protected, now we've got that DMCA Veo Networks problem. They didn't lose because of liability. They got obliterated because they had to litigate whether they were protected from liability in the first place. So every time you poke a hole in Section 230, that's why I said it's a balloon, and it just pops because you've just signed up for more lawsuits to figure out whether Section 230 applies to you, in which case it really doesn't matter anymore whether it does. But I think the question that we can come back to is sort of a different one, which is we're getting caught up in the Section 230 debate because I don't think we're upset with what's happening on the internet, but I don't think our concept of what the internet is accurate anymore. I think it's basically like we've become so inured to a couple of the big tech players as being so definitional to what big tech is that, you know, if that was truly the world where you got Google, Facebook, Twitter, throw in a couple others, and that was it, I don't know, maybe you do rethink Section 230. I'm not signing up for this. Do not quote this for me. I'm just kicking it around as an idea. But that's not it. That wasn't what it was before. We're not entirely sure we'd even want it to be now. There's an awful lot of stuff happening on the edges and we're not paying attention to it. And what 230 does and did and does brilliantly is help make sure that we can get that stuff on the edges. And especially now that we're so upset about the big players, and we'd like to have more competition for them. We absolutely need to be looking at the edges, but we don't recognize that they exist. And I think of a joke that actually came up in the 90s, because I talked about those walled gardens. Like AOL was like AOL only. It was a big deal when it poked a hole and you could actually sign up for AOL and use it as the ISP to go surf the information superhighway on the World Wide Web. There was a joke that like people who thought AOL was the internet were the same people who thought Taco Bell was fine Mexican cuisine. Like, it's just too narrow. You have to think more broadly about these things. So that's my comment here. We have to think more broadly about what the internet actually is, because it's not these players, and we should be able to have these policy discussions without ever mentioning Facebook.
So, Adelin, sort of taking that as a lead, from the operational side, from a trust and safety side, if there was a situation, if there were no 230 and you were in this scenario where the decisions that a trust and safety team were making would potentially impact legal liability and potentially cost the company a lot more, operationally, how would that even work, or would that work? What would happen to companies if they sort of had to run every decision by legal effectively?
Yeah, it would not be good. It would actually mean that people like me probably wouldn't really have a job, because then you just put lawyers on every single decision rather than having a separate, trust and safety operations team. I already see this tension a little bit with some of the copyright stuff, right? Because you have, folks who are doing the intake for these removal requests or legal removal requests. And when things get, kind of hairy, right, we escalate to legal. And some, on your worst days, when you're escalating everything to legal, you're sort of questioning, like, why am I even here? I'm just like pushing a paper around, right? Like, just have a lawyer do this work, but lawyers don't really like to do operational things at companies. So that's why we don't have lawyers processing these DMCA tickets. So, in the instance where, everything would have to be sent to a lawyer, I can only imagine that being really expensive to do, because lawyers are very expensive, and you wouldn't have kind of this intermediate team helping you scale, which means everything moves really slowly, right? Because what, in my experience, what the legal team would probably want to do is do a lot more case-by-case investigation, and try to understand the nuance of each ticket that comes in. Whereas, like, as an operations team, what we're trained to do is to move volume, right, to scale. And that's why we have to create these rules that allow, there's no such thing as objective, but, we create a set of as objective criteria as we can in order to move and process complaints and reports and reviews as quickly as possible. I think the other really kind of worrisome thing is that, the expectation that you would be reviewing every single piece of content on the platform, even if we weren't escalating everything to a legal team, it's just sort of, when you're a really, really small platform, or you're like the moderator of a really small community, that's scalable, right? Like if you were a live journal back in the day. But at the scale of Facebook or Google, like, that's just really kind of impossible. So then you're relying on automation to review content. And what gets tricky is, well, then do you start looking at, very minuscule, or like, what's the atomic unit that you start reviewing? And then that brings into question like a whole lot of questions around a user's data and a user's privacy, and like, what are they entitled to post without you kind of digging into their business. That is not an area that I'm an expert in, but I can only imagine from like a user point of view, like the backlash would be pretty significant, because people like to have some degree of separation between the things that they're putting, or there is an expectation today that there is some degree of separation between the messages I send you, right, and whether or not a company can look at that. And when we disintegrate that, I think there's a lot of, terrible downstream effects. But that's, I think, if that's what if we lose that protection, I can only imagine it's a little bit of a slippery slope into like, okay, like, we're going to run automation to take a look for this particular word, and each word can have multiple meanings, but you know what, we're going to look for that that word in every single post, every single DM, because if we don't do it, we get into trouble and our business is gone. So that, I think, is really problematic.
Yeah. Kate, one of the things that you've certainly studied a lot and written, a ton about, is the fact that, how often these things are changing, and how often these companies have to make adjustments in terms of their policies, and how they're reviewed. And for folks who are interested in this, beyond reading absolutely everything that Kate has written, she's got papers, New Yorker articles, New York Times stuff. Like there's a ton of stuff out there, all of which is worth reading. If you like listening to stuff, I highly recommend. There was a Radio Lab episode that you're in, that sort of goes deep on some decisions that Facebook had to make, and I think does a really excellent job of illustrating, like, okay, we have a policy, and then it's like, oh wait, there's an exception. Like, oh geez, how do we deal with this? Okay, maybe we write an amendment, and then all of a sudden, like, you find another exception to that amendment. You're like, oh wait, we have to think about this. Can you talk a little bit about, like, just the reality of content moderation for these platforms at this kind of scale, the ability to actually adjust and change as they realize that, like, all of the things that I think a lot of people on the outside think are kind of black and white, like, this is good content, keep that up, this is bad content, take that down. The reality is that, like, most of the content is in this, large gray area, and you have to sort of keep adjusting and changing. So can you talk a little bit about that, and sort of how that works within companies?
Yeah, I mean, I guess it really, I think that there is a trend. So I think that when I started studying this, I would have to, so this was, again, just like 6 years ago, I would give, like, when I was in the market for a professorship, and I would give my job talk and my paper, I would, like, have to start the entire conversation with, when you publish things on Facebook, they don't always stay up on Facebook. And it's not, and, like, people will be like, oh yeah, like, some super smart AI takes down child pornography, like, thinking that it, like, not like there is some type of algorithm that takes down child pornography, but it doesn't work how they think it does. It does not, like, know that it is a child in the picture and know that it's sexual activity. It is actually just a matching thing, because humans have put this huge database of known kind of what we call CSAM images, like child sexual abuse material, into a database, and that known universe can be checked against using, like, a hash matching system against kind of anything that's uploaded on the site. It has gone from much, like, that was like, CSAM was and photo DNA was kind of, and a little bit content ID, which is how they do it, is how YouTube in particular does it, to match before upload something that is copyrighted, and, like, someone is using, like, an excerpt from too long an excerpt from a copyrighted song, or some type of, like, sequence from a movie that is not, like, that is copyrighted, and to block that from being taken up. That type of, I call it, like, ex ante content moderation, because it happens before it's published to the rest of the world. Not that it's published on Facebook servers or something, that it, like, that's a different line, but that it's before it's published to the rest of the world, is where increasingly huge amounts of content are blocked from ever appearing. And in a legal kind of a First Amendment kind of analysis, we'd almost call this like a prior restraint type of type of thing. It doesn't even get to see the light of day, and then we have an injunction to make it come down or something like that. It's actually just before anyone sees it, it's being memory hold. And so this is now how a lot of stuff comes down, not just for copyright, but for CSAM, but for terrorist material, and a number of other things. And the sites themselves have started to create their own internal databases for content that they know recurrently comes up and isn't explicitly illegal to post, like copyrighted material, CSAM, or terrorism. And so what you have is, like, exactly kind of as Adelin said, is that there are these words that become, like, there are these words, these natural language signifiers that AI and algorithms, like, recognize, either before it's actually published or after. They run them afterwards. Because let's give an example of Stop the Steal. Before January 6th, there was no natural language ban on Stop the Steal, but there was a lot of content that had gone up discussing using that specific terminology of stop the steal, and Facebook ran what I would call a post hoc algorithm, like after publication, ran a natural language algorithm on things that had appeared, saying stop the steal, and removed them, or like basically demoted them. And I think that but a lot of this stuff is actually still being done by human content moderators in assistance or in tandem with either how you bucket things or how AI recognizes certain types of things and then sifts them to content moderators. But that being said, there's still like, for every 100,000 people on Facebook, there is one human content moderator. It is still like a tremendous amount at scale that like these companies are expected to be adjudicating. And in the event that you get rid of 230, one thing that and Adelin kind of hinted at this, one of the things that I would endeavor to say is you put a lot of pressure on the individual laborers that are already doing a really crappy job of having to work and clean up the worst parts of our humanity from the internet. You make their job a lot worse, because what if there is something that they don't recognize as defamation for some reason, and it gets through the cracks and Facebook gets sued for $10,000, $100,000, $1 million, right? And they don't recognize it. And now all of a sudden, do you think like if they're running with that type of decision-making framework in their head, of course they're going to like side on the side of kind of more censorship and taking more things down. I want to endeavor that that's not even a corporate policy. Facebook doesn't have to tell them that is not something. It is all like soft, just behavioral like ramifications of what this policy would do, is that essentially like it would create liability for the people on the front lines doing a bunch of this work. And the one last thing that I'll just mention that I don't think that like Cathy kind of talked about with kind of the small actors, like, you know, and then we saw this with Gawker, right? Gawker got sued out of existence, right? But the New York Times doesn't get sued out of existence. What's really frustrating for me right now is that we're so concerned about how big these tech companies are, and we're so concerned about monopolization powers. If anything, Section 230 would absolutely create a barrier of entry for new entrants to the market. It would make it so that like you wouldn't have as many little gawkers, you wouldn't have as many like little, you know, as many kind of websites, and that they never even mind the Reddit that like might change their policy, and like that would change the very nature of kind of what stays up and comes down on the site. Like, you just wouldn't have as many people because they would be able to be sued out of existence, just like Gawker was, like versus like the New York Times. And so I think that when we're talking, what's so weird to me is that you have certain people calling for this level of 230 reform where basically they want to make it easier to sue these platforms without realizing that this would really entrench the established players, and that you would actually make the monopolization like parts of this so much worse. And I wish that was more of a conversation. I mean, it makes perfect sense when you kind of think about it, but no one is doing the next step of kind of thinking about the downstream effects of what would happen if you got what you wanted with all of this 230 and what you wouldn't get. So I think that's the frustration.
Yeah, I think that's a really good point, and actually works as a really good lead in to the next thing that I wanted to discuss, which is there has been one reform to Section 230 that got through, which is the law that now is referred to as FOSTA, which put an exception to Section 230 when it, without getting into all the specifics, sort of relates to sex trafficking. What was interesting there is it's created a whole bunch of other issues, I think some of which have been discussed on other panels at this conference, that were, you know, even though lots of people warned that these consequences were going to happen, were mostly ignored. And I think people are now realizing the problems there. But one sort of very simple example of it is as soon as FOSTA went into effect, Craigslist, for one, shut down the dating channel on Craigslist. And a few other dating sites also shut down or put much more significant restrictions on what they could do.
And Tumblr took down all of its...
And Tumblr took down all of its adult content and ended up selling for pennies, because apparently the adult content was fairly important to traffic on Tumblr. But there were some pretty widespread impact to FOSTA going into effect. But one thing that is not talked about as much with that, which is that a few months later, Facebook announced their dating service. So you have this sort of very like clear example of like Craigslist shuts down their dating service in response to this change to Section 230, and Facebook launches a dating service a few months later. So like Facebook in a lot of cases can handle this stuff, and the smaller companies cannot. So you get that the exact example that you were pointing to of this, consolidation, concern about dominance or competition, where reforming 230 might give you the opposite of what most people think it would do. And so related to that, I did want to bring up just this week, there's a new bill out, and I know earlier we talked, a lot of the Section 230 bills are sort of performative fundraising, grandstanding vehicles for politicians to just get attention and have no chance of actually going anywhere. The bill that came out this week was a reintroduction of a bill from 2020 called the Earn It Act, which takes a very FOSTA-like approach for CSAM, which we were also just discussing, and basically saying there's no exemption in that. You can't have an exemption in Section 230 for CSAM. And then it also has a separate part, which I think is also probably interesting to a lot of attendees here, that it effectively attacks encryption. And we can get into the specifics of why and how, if that's necessary. But Cathy, I wanted to talk about Earn It, because I think it unlike most of these bills, it has, I think, 19 different senators signed on as sponsors or co-sponsors, and bipartisan. So it has an awful lot of support, and is really, an attempt to reform Section 230 that might have real power. So Cathy, do you want to talk a little bit about Earn It and kind of what it does and what the concerns are there?
Can I say no?
I understand you might not want to, but I think it's important for the people here to hear about it.
Well, quite frankly, one of the problems is those of us who try to not have 230 fall apart are a little tired. There's been bill after bill after bill after bill, and this one is, my brain isn't fully there. I was busy complaining about it last year, and I haven't fully briefed myself on all there is to complain about it this year. But let me talk general broad strokes of things that would be terrible and are probably in this bill too, because it's terrible. I mean, and some of what we've talked about is just this whole idea about what it is that you're doing. One of the things that shows up, not necessarily in Earn It, but in some of the other bills that have come up, is this mistaken notion that Section 230 is a special privilege, and that we want to conditional that privilege. Like if a company is not good enough in another area, and maybe they're not. I mean, companies are large, complex, and sometimes innocent actors and sometimes bad actors. So they may need some hand slapping in certain places. But this idea that if they needed their hands slapped, we're going to take away their Section 230 privileges. It's not a privilege. It's a fundamental part of making the First Amendment meaningful so that every single platform can exist on the internet. So I don't think Earn It necessarily does that, but some of the other bills that have been proposed come from that standpoint, and that's bad.
I mean,
but I think
Earn It does kind of come from that too.
Because it's baked into this idea of be good, and now it's all coming back to me. The nightmares, the flashbacks. But this idea that if you are not good enough here, we're going to take away something you really like having over here, as if, no, you didn't eat your Brussels sprouts, so no dessert for you. That's not also how Section 230 works. It's not how it can work. Because the other point that I raised talking about this balloon is you can't have the friction and still expect it to be a meaningful protection. The point is, when people like Adelin are doing their job, she shouldn't have to think about this. She shouldn't have to have is this legal, is this not legal? She should just be making the decisions of what are the best decisions we can make for our community. That's hard enough. That's what she should be worrying about. And every time you make Section 230 an if and not a that, you add that friction and you make everything harder, less useful, and you're never going to get good results of it. So the fact that they're taking the biggest, most profound, provocative issues of CSAM, this is bad, this is stuff that actually needs an appropriately tailored policy problem, and you're just throwing bricks at it with no nuance, no understanding, no operational understanding of what this would do, how it affects people's jobs, what they would actually do. Like, they have to be good enough. What does good enough even mean? And now you're going to like take recess away from everybody. This is terrible. And what the conversations earlier this week talking about like the devastation of FOSTA is, it doesn't just destroy things generally, but it tends to actually really specifically hurt exactly the same interests who ostensibly the bills are supposed to protect. What happened to sex workers is terrible. There is a body count associated with FOSTA, and they, in theory, were the people that this bill was supposed to be standing up for. That's ridiculous. That's like grossly negligent lawmaking, and we should not be tolerating it. We should be looking at the effects. And what people are also pointing out, like, now you're going to drag in encryption. You're going to talk about the most fundamental things about why free expression is important to fight against democracy, while like people in Ukraine are like desperate to be able to talk to each other with some security so that they don't get invaded and attacked and, you know, terrorized. Like, how can this be consistent with our overall policy to be chipping away with anything that protects the free expression that democracy and freedom depend on? Don't do it. It's terrible. Like, the details of this bill, yes, they're worth talking about in some detail, but the details aren't the issue.
Sure.
It's fundamentally misguided in terms of what it's trying to do as a regulatory solution, and will only hurt, including and especially what it's ostensibly trying to help.
So just for background, because I think the discussion on EARN is going to be important, and I do think it is important for. I will give a sort of very kind of a quick. Quick summary of Earn It in the loosest terms without going too deep into the weeds. But basically, it creates an exception for CSAM and says that, you know, platforms that have CSAM don't get 230 protection, which would you know, be interesting to discuss if there were cases of companies using Section 230 to protect themselves against lawsuits involving CSAM, and those don't seem to exist. So it's unclear what problem they're actually solving. In the documents that are presented by the sponsors of the bill in support of it, they're claiming that different companies don't take CSAM seriously enough, and that this is somehow creates an incentive for them to take it more seriously. But that's actually, again, not how the law works, and how, you know, what a lot of was discussed earlier, you know, it then becomes a question of actually who has knowledge of different things. And by exempting it from 230, you're actually creating more incentive for the companies not to have knowledge, because if they don't have knowledge, then they don't have liability. So by creating this thing that says, like, now you might be liable if you have knowledge, that actually gives companies less incentive to search out or to install a database, you know, to use something like PhotoDNA or one of the other services that are out there to try and find CSAM. So the end result is I think more dangerous, and actually puts, you know, creates a bigger CSAM problem than the situation that we have now. And then the attack on encryption is basically, it's really tricky and in an annoying way, in that there is a section in the bill that kind of says, like, this doesn't impact encryption, except it does, because of the language that is used. It says that, like, basically a company cannot be sued under this bill solely for having implemented encryption. However, it says that the fact that they use encryption could still be evidence that they are a bad actor and are basically trying to hide from the fact that they have CSAM on their platform, which then makes, you know, having encryption, end-to-end encryption on your platform a liability, you know, and a risk that you would have to fight over in court. Moving on from Earn It specifically, there's like so many different issues that we could go down the path on. You know, one of the debates that's come up this week, you know, really the last couple of weeks, is like, you know, whenever content moderation questions come up, people sort of run to 230 as if that is the underlying cause of anything. So right now there's been this big fight over Spotify, right? And Spotify, should they be hosting Joe Rogan or not? I see the scowl on Cathy's face. And there's been some discussion. People keep bringing up like 230. I'm on both sides of this, like, you know, whether or not Spotify should host Joe Rogan. My argument, and I have a blog post that's going up sometime today, is that this is not a 230 issue at all, but a ton of people are considering it one. So am I wrong? Is it a 230 issue? Is Spotify determining whether or not to keep Joe Rogan on the platform, or is it not a 230 issue? Cathy, I'll toss that to you first.
I mean, there's, I think, two questions rolled up into it. Technically, is it a 230 issue? Which is an interesting question. And, you know, is it a technical question or is it an analogy question? Because I think some of this is, the technical question isn't the interesting one. It's this idea of thou shalt be responsible for what somebody else has done. And this is a recurrent thing that's showing up in all of the Section 230 pushes. The idea that we want platforms to be their users' keeper, and that we want to hold them accountable if they're not. And to some extent that makes sense. But in some sense it gets carried away and starts to become poisonous, and then you turn into like the discussions about cancel culture, some of which are ridiculous and some of which actually do make sense. I want to say no, it's not a Section 230 issue, just because I don't want the provocative feelings informing this discussion to be tainting this policy area, which is too important and needs to get right technically. So I'm going to say no, although I'm not sure that technically that's necessarily true. If they were getting sued, they would have an interesting Section 230 defense. But I think the larger cultural thing about like, what does it mean to be associated with other content, that's an interesting question, but I don't know if it's always being discussed in an interesting way. There's a lot of reaction that isn't particularly useful.
Mike, can I jump in really quickly? Because I have to take off and teach 75 1Ls adverse possession, which is the only thing I like discussing even slightly more than Section 230. But I will just say that I don't think that there is no part about the Joe Rogan thing that is a Section 230 thing, except that it's on the internet. It is 100% like, except that people mistake it for a Section 230 thing because it's on the internet. That is like literally the only, that's like the meta, not the meta Facebook way, but the meta way of like actually thinking about it. Like if we say that every internet problem is a 230 problem, will it eventually suddenly turn out to be true? I hope not. But no, it's a First Amendment problem, at least from the thing. And also, Adelin, is that a very fuzzed up version of your cat that is appearing in your screen?
I'm so sorry. I should have fed him before. Like, I hopped on this call and he's ornery.
Thank you guys so much for a great panel, Mike. Thanks for this. And I'm sorry that I can't stay to the end. It conflicts with my class time. So talk to you guys soon.
Yeah, no, thanks so much, Kate, for joining us and taking part. So I'm gonna jump. We've been getting some questions in the Slack, and I want to bring some of those questions in because I think there's some really interesting ones. So, someone asked whether or not some of the new proposed regulations regarding transparency and fairness regarding the algorithms are actually a sufficient answer to these different challenges in terms of how companies deal with this content. So and I know there's been a push for like, if the companies were more transparent about their policies, somehow that would solve things. I mean, some of the laws go so far as say like you have to be transparent, and then if you make a decision that disagrees with the policies, I think that becomes really problematic. But what do from Cathy's standpoint, the legal aspect, and from Adelin's standpoint, if you had to be really transparent about the policies, does that change anything? Does that fix anything? And Adelin, I'll go to you first in terms of like, if there was a law requiring the companies to be more transparent and reveal either their policies or like the details of how the algorithmic stuff worked, would that how would that work in practice?
Yeah, I think, I actually, can I just make one point with talking
absolutely.
about the Earn It Act and CSAM, because it just kind of wanted to flag that in all my years of working in content moderation and working with teams that have had to touch upon CSAM in some way, shape, or form, whether that's like on the trust and safety side or on the technical side or on the legal side or even other places in the business, I have never met a single person who did not care about child sexual abuse material on the internet. And so for there to be an impression that the companies don't care, I think that's a poor misconception about what's happening at these companies, because I've never met a single person who said, oh, you know what, I'm just not going to resource this. There are issues that come up around resourcing, which are fair, but people do care about it. And I just think it does a lot of individual people a disservice when we talk about the tech companies as, these monolithic entities without thinking about the real people who are encountering this content every day and trying to do the right thing. But anyway, on to transparency. So I think there actually has been a pretty proactive, I guess, like movement for companies to be very transparent about what they're doing. You see that, back in the day when I was at Google, we were actually revamping our help center to be super transparent about all the things that we considered, out of scope or within scope of a policy. We gave examples. We tried very hard to explain things. I think even on the engineering side, there were a couple blog posts about like, hey, this is how we, determine from an automation point of view if something is problematic or not. But there are going to always be certain areas where transparency is just not feasible, right? Because people start to game the system, and then you start to see people coming right up to the line. And that's possibly what's happening in the case of Joe Rogan, right? Where you are very clear about your policies around what constitutes misinformation, but people are going to use that information and get really close to the line. So there's always going to be that gray area that requires more discussion or more escalation. But in my opinion, I think, you could ask for more transparency for sure. I think a lot of the companies are doing their best to be as transparent as possible without, revealing too much about the secret sauce of their own business, which I think is a very fair thing to protect because that's proprietary, business information. And, I've seen companies, I'm not trying to be like a shill for these companies, even though I recognize I'm starting to sound like one, but I feel like also the teams that I've worked with have tried to bring in outside perspectives, on a more quiet basis, to take a look at the policies and say like, hey, are we doing the right thing? And being transparent and private, right? Which I guess is a very odd thing to kind of counterintuitive thing, but I think that really does help to bring in civil society groups to poke holes at your policies and provide you with input, and also to take a look at your algorithms, right? Particularly with the conversation around algorithmic bias. I know of teams that are trying to do the right thing by bringing outside experts in and being transparent with them in order to build better policies. But I think full transparency is just going to be a little bit harder for companies to get around to, just because there are so many ways to game the system. But yeah.
Yeah, I think that's actually a really important point, and one that is really very rarely discussed on the question of transparency is how much of there's obviously benefits in being able to have other eyes look through it and go through it, but some of those eyes are the people who are trying to game it, and oftentimes it's the abusive users or the trolls who are, who want to know the exact line that they can get up to, and also want to litigate every decision and say like, well, your rules say, as long as I don't do this, I'm okay. And so the fact that I did everything to sort of pretend I wasn't doing that becomes an issue. And then, the other issue that I've seen is again, sort of like the disparate impact on different types of companies as well, in terms of, can a Facebook or a Twitter put together a team to sort of present the rules in a transparent way and continue to adapt and change and do that? Sure, they have the money to do that, whereas smaller companies that are sort of forced to do this, it becomes then like a huge task for some of them to handle the transparency. Cathy, did you want to discuss the transparency angle from the legal perspective?
Yeah, I mean, there's a gigantic First Amendment issue sitting here. And think about it as like your own self. Like, if you're on Twitter and you're retweeting things, well, you're kind of amplifying some things. Well, explain yourself. Why did you do that one? Why did you do that? And you better say so, because your legal rights are going to hinge in the balance of, did you say so in arguably in a way that we approve of? Like, why did you amplify? Defend yourself. Like, don't you find that a little bit chilling if that was the law you need to live within. Well, if that's chilling and sort of contrary to your own First Amendment expressive interests as an individual, why do we think that that's not the case when you've just glued a whole bunch of individuals together in a company? Like, if it's true that your First Amendment rights get extinguished at a certain size, we need to be able to articulate very clearly when, wow, and how and why, because that's a pretty big deal. Um, and so if you think about that, like that, thou shalt do it. Like, I don't know. Let me ask Adelin, like, if you had to defend every decision, would you find that? I'll ask a leading question. Would you find that chilling?
Yes.
Okay. So the fact that there is that effect is sort of like, this is why it should not be in law. Now, otherwise, I think it's kind of interesting. I've written posts like arguing that transparency is good. I'm most concerned about, like, I like the transparency reports when they report when did an external pressure drive the system. That's the stuff I really want to see, because that's the thing I really want the most illumination on, of like, when I don't really mind however like arbitrary a platform wants to be. Adeline, do whatever you want. It's totally cool. Like, because if you do a terrible job, you'll just lose your users, and that's your consequence. But like, do whatever makes sense for you, and like, okay, fine, learn about your community so you can do the best job for them. But like, whatever. If you really screw it up and your users wander away, then that's on you. But when somebody is like pressing on you to make you decide things in certain ways, like, I really care about that, and your users will care about that. And that's the thing I really want, transparency. But like, even to mandate that, like, again, like, explain yourself now. Like, no, that's compelled speech. And there's a reason that the First Amendment says don't do it. I mean, the First Amendment like says don't do an awful lot of speech that might be a good idea, but when you force it, it's not freedom, and then like you lose that free expression, and then like the whole house of cards falls down. So
Yeah. Oh,
not a good plan.
Adeline, go ahead. Sorry.
I was also just going to say, if you're mandating transparency at a certain level and requiring, reporting of certain things, given the diversity of platforms and companies that exist, you can't really have an apples to apples conversation about those metrics, right? And I think that that's also, it's not just the data about kind of what's being removed and how things are being removed, but there's also an analysis portion that gets lost in the mix when you're requiring a certain standard. Right. And if we're only going to look to the Facebook or Google or YouTube standard, we're doing all of these other platforms a disservice, because then we're not actually understanding how they're doing.
Yeah, I mean, I think that's a really good point. And one of the things that I point out is, like, look at how a rule like that would impact certain other platforms like Reddit. Or Wikipedia. I mean, Wikipedia to some extent, right? All the edits are transparent, but the reasons why are not necessarily. And Reddit, you have different subreddits that have their own rules and their own moderation, and how do they put forth a sort of more transparent explanation of that? The other example that I've used, and that I think gets to some of the points that Cathy was making, was when you talk about the transparency for the decisions, it's like, if Congress put together a law that said, like, Fox News had to be transparent about who they chose to put on on Fox News and who they chose not to put on, or the New York Times had to explain who they were willing to publish on the editorial page and who they weren't interested in publishing on the page. I think everyone would sort of recognize that's a First Amendment issue. The editorial discretion that Fox News has and that the New York Times have, that's protected by the First Amendment. And so, demanding the transparency of the platforms raises some serious First Amendment issues related to that. So, another question that's sort of come up, and I've seen this one a lot, and it came up in the Slack as well, is, when you're talking about sort of like the algorithmic promotion of content, does that change the calculus in terms of, if Facebook is promoting this content, and there's some arguments and some people have pushed for laws that say, like, if the algorithm promotes the content, you no longer get 230 for that. And so, what would the impact be of that? Should 230 apply to content that is algorithmically promoted?
I think the answer to the question is, do you think that bookstores should potentially be liable for the books that they sell because they put them in the window? Like, algorithmic promotion happens all the time. We're usually cool with it, but it also kind of, in that context, you can sort of see why it needs to happen. the pivot point for 230 is really who created it, and in particular, like who imbued it with the particularly wrongful quality. And there's a lot of arguments that people will throw that, like, well, if you enabled it, attracted it, facilitated, amplified it, you've created it. But you really know that's asking for too much. Legally, that needs to be much more separate. Facilitating or promoting or amplifying is not the same thing as creating the content and imbuing it with the wrongful character. And it's really important that Section 230 pivots on that point about whether you're the protected ICS or whether you're the information content provider who's not protected. It's hard I think, for people to get their heads around because it feels like a handshake, but I think it's important that we don't go out of our way to find that handshake. That's a really important delineation that will be 230 scales better and more usefully, and protects the First Amendment more successfully when we don't construe creation to facilitators. So no legally, and no, we shouldn't anyway.
So a sort of related question that I think comes up a lot is this idea of whether or not product liability laws are a way to get around 230, or should be a way to get around 230, where they say, you designed your product in a way, and this touches on the sort of amplification question to some extent. You designed your product in a way that, enabled, this bad content to be more prominent, and therefore you are liable for it because you were, or you were negligent in how you designed your product. Do you have a response to that?
There be dragons. This is because one of the things we have to recognize, how much of this is speech, how much even the creation of the platform is an expressive activity. This is based in code. Code is a language. Code is a language you've now expressed. This isn't the same thing as designing a physical car where the nuts and the bolts were weak and couldn't hold, so your wheel fell off. And drawing the analogy between the two is a really, really, really bad idea, because it does not stay constrained to, well, I don't like this particular use case. In this particular use case, somebody got hurt. I don't want to poo-poo that, but your remedy is something where if you can find liability there, you can find liability everywhere, and bang goes out all sorts of websites, free expression, e-commerce services, all sorts of stuff. So you can more clearly draw a line to say, no, this is not the same. This is speech issues, and negligent design of how you facilitated expression. Imagine your favorite totalitarian, using that language on his dissidents. I'm sorry, you facilitated that language and they did something that offended the national security law of Hong Kong. That language could be scaled by all sorts of people who want to make sure that nobody can speak freely.
It also seems a little bit like an oversimplification of kind of what a product is to me, right? Because there are, particularly with content moderation, I think one of the things that I really hope more folks will get a more sophisticated understanding of is that it's not just about leaving up content and taking down content. Right? There's a whole array of things that go into the complexity of content moderation. You could do you could do things like throttling the popularity of a piece of content. You could hide a piece of content from the broader public and only allow it to be visible to a select few people. Lots of platforms do that. You could prevent recommendations. You could inhibit certain things from showing up in search results, right? So to have kind of this kind of blunt approach to hey, your product messed up. Yeah, my product can mess up in a million different ways, right? Because I have 3 engineers working on different parts of the product, and sometimes they forget to sync up, right? And therefore we allowed it in recommendations, but we should have taken it down, et cetera, et cetera. There are a lot of places for these things to go wrong, and so I guess the complexity of how content moderation is done, it just seems to me that having a very blunt statement around, hey, you messed up and therefore you don't get all of these privileges, it just seems like a very difficult conversation. And that means that the really risk averse among us would not even want to start delving into that world at all. And I think that's really bad for the internet.
Yeah, I think it's a really, really good point. And I know we're we're getting close to the end here. So it's actually a really good point, I think, to emphasize, because it hasn't been discussed as much, which is like so much of this discussion is always focused on like the take up, leave down aspect. And that's, you know, less and less important in some sense to content moderation, and the fact that you have all these different solutions, or you have things, you know, which has really only become common in the last couple of years, where, you know, companies are adding more information, right? So like, you know, putting a flag on content that this might be misleading, or, you know, putting an interstitial tool that shows up. It's like, do you really want to share this? You know, this has been known to mislead other people, or something along those lines, or, you know, employing fact checkers. You know, all of this kind of stuff is there are different approaches, and it's Section 230 that allows for this variety of approaches, that allows for this, you know, broader ecosystem of possible interventions beyond just leave up, take down, shut down this account, or whatever. And, you know, I know like Eric Goldman, who we all know and love, had put out a paper, I guess about a year ago, of like all the different interventions beyond leave up and take down. I forget what the paper's called, but I think it has like beyond leave up, take down, or something like that, where he looks at, you know, and just sort of like creates this sort of taxonomy of like, there's so many different options. And if you had a world in which there was like product liability or potential of negligence for the choices, what would happen realistically is that there would probably be a few big lawsuits, and courts would determine this is okay. If you do this, it's okay. And then everybody would follow that path to avoid legal liability. And you wouldn't get all this experimentation. You wouldn't get all of this variety. You wouldn't get different platforms trying different things for different communities and sort of matching what makes sense for the different communities. So I think it's really important to sort of to recognize how much Section 230 allows for the experimentation and the sort of, you know, iteration as we go through this, and as these companies try and improve and try to provide different, you know, different results for different services. And with that, I think we are out of time. I didn't get instruction on how to end the panel, so I'm sorry from a distance. I don't know if somebody comes in and pulls the virtual hook to pull us off stage, but I do believe we are out of time. But thank you both. While I'm waiting for the virtual hook, thank you both for taking the time, and thanks to Kate, who's no longer here and is teaching, for having this conversation on what I think is a really important topic.
Thanks for moderating, Mike, and really nice to be on a panel with you, Cathy.
Oh, same here.
Okay, thank you to the panel. Can we all take a moment to thank the panel for their time today?